Hello everyone, welcome to USA State. Big news just broke that could change everything for thousands of families waiting on immigrant visas. A federal judge has struck down the Trump administration's ban that had frozen immigrant visa processing for people from 75 countries. This is one of the most significant immigration court rulings of the year, and it directly affects applicants from nations across Africa, Latin America, Europe, and Asia. In this video, we're going to break down exactly what this ruling means, who is affected, what happens next, and what you should be doing right now if you or your family have a pending immigrant visa case. If you are interested in this topic and liking this video, please stay tuned until end of the video. If you are liking this video, please hit the bell button, subscribe, and like it so that you may get updates straight to your smartphone. Now let's get into the video. Let's start with what this policy actually was. Back in January, the State Department quietly paused the issuance of immigrant visas for people from 75 countries, which is roughly 40% of every nation on Earth. This wasn't a ban on tourists or students. Non-immigrant visas like B1 and B2 visitor visas, along with student visas, were not touched. This was specifically about immigrant visas, meaning the permanent pathways people use to join family members in the United States or to move here for employment-based green cards. Countries affected included Brazil, Colombia, Egypt, Haiti, Somalia, Russia, Afghanistan, Yemen, Albania, and Pakistan, among many others. According to sources familiar with the policy, the official justification was what's known as the public charge rule. This is the idea that an immigrant should not be admitted if they are likely to become primarily dependent on government assistance once they arrive. Under normal circumstances, immigration law requires a consular officer to look at each applicant individually. That means reviewing their finances, their age, their health, their job skills, and whether they have family members in the United States who can support them. That is how the public charge determination is supposed to work, on a case-by-case basis. However, here's what made this policy different, and ultimately why it ran into serious legal trouble. Instead of evaluating people individually, the State Department issued a cable, essentially an internal instruction sent to every single American consulate and embassy around the world, directing officers to reject applicants from these 75 countries almost automatically. Reports suggest that even when someone provided clear evidence that they could support themselves financially, their application could still be denied simply because of which country they were born in. Immigration experts note that this is a critical distinction because deciding someone's fate based purely on their nationality rather than their individual circumstances runs directly into a decades-old federal law. That law is the Immigration and Nationality Act, first passed in 1952 and amended in 1965. One of its core provisions says the government cannot discriminate against a visa applicant simply because of where they were born. This is the exact provision that ended up at the center of the lawsuit filed against this policy. The case was heard in the Southern District of New York, and on Friday, Judge Jeanette Vargas issued her ruling. She did not mince words. The judge called the policy contrary to law and said Secretary of State Marco Rubio had exceeded his statutory authority in issuing it. In her written opinion, Vargas explained that requiring blanket denials based solely on nationality, rather than individualized review, violated the plain language of the Immigration and Nationality Act. She specifically pointed to the internal cable as evidence that consular officers were told to refuse visas, even for people who had already demonstrated they could overcome any public charge concerns. The ruling did two important things. First, it vacated the policy itself, meaning the 75-country ban is no longer in effect as a matter of law. Second, and this is the part many applicants have been waiting to hear, the judge set aside any visa denial that was based solely on this policy. In practical terms, that means if your immigrant visa was denied specifically because of this nationality-based rule, that denial has now been thrown out. So who exactly is affected by this ruling? The first group is people who already had their immigrant visa applications denied under this policy over the past several months. If you are a family member of a U.S. citizen or green card holder and you were denied because of this ban, your case may now be eligible for reconsideration. This could include petitions filed on forms like the I-130, which is the foundational petition for family-based immigration, as well as cases moving through consular processing using the DS-260 immigrant visa application. The second group is applicants whose cases were simply frozen or delayed, sitting in limbo because their country was on the list. With the ban vacated, the State Department is now expected to resume individualized case-by-case evaluation for these applicants, rather than blanket denials. The third group, and this one is often overlooked, is American citizens and green card holders themselves. Many of the plaintiffs in this lawsuit were not the visa applicants at all. They were U.S. citizens whose spouses, parents, or children were stuck overseas because of this rule. Advocacy groups involved in the case, including immigrant rights organizations that helped bring the lawsuit, framed this ruling as a victory for keeping families together, arguing that the policy was tearing apart households that had done nothing wrong except come from the wrong country on a list. Now let's talk about the broader implications, because this ruling does not exist in a vacuum. This is part of a larger pattern we've been covering here on Immigration Update, where the current administration has pursued aggressive immigration enforcement policies, only to see a number of them challenged and struck down or narrowed in federal court. Legal analysts suggest that this pattern reflects a consistent legal issue. Courts have repeatedly found that policies imposing broad, categorical restrictions, rather than individualized case-by-case decisions, tend to conflict with the specific language Congress wrote into immigration law decades ago. Despite this ruling, it is important to understand that this fight is likely not over. The Trump administration retains the option to appeal the decision to a higher court. When reporters asked for comment, a State Department spokesperson declined to discuss the specifics of ongoing litigation, but reiterated that the administration considers strict screening and vetting of visa applicants essential to protecting the American public. So while this ruling is a major win for affected applicants right now, it would not be surprising to see the government push back through the appeals process in the coming months. Now let's get into what this actually means for you if you are currently in the immigrant visa pipeline. In practical terms, if your case was denied under this specific policy, you may want to reach out to your attorney or check directly with the National Visa Center about reopening or reconsidering your file. The court's order specifically requires the State Department to restore lawful, individualized evaluation, so cases should no longer be rejected purely because of the 75-country list. For those whose cases were pending or delayed rather than denied outright, this ruling should, in theory, unfreeze the review process. That said, we always recommend some patience here. Court victories like this one often take real time to translate into actual operational changes at consulates and embassies worldwide, especially given how many cases piled up during the months this ban was active. If you are working through categories like the CR1 or IR1 spousal visas, the F2A category for spouses and children of green card holders, or employment-based green cards under the EB series, keep a close eye on your case status and any correspondence from your consulate. There is a genuine silver lining here, though. This ruling reaffirms that individualized review, not blanket nationality-based rules, is what the law actually requires. That protects applicants going forward, even if the administration tries similar policies again down the road, because courts now have a clear precedent to point to. Many immigration attorneys are advising clients to keep their documentation current and ready, including financial evidence and affidavits of support, so that if and when your case is reopened, you are prepared to move quickly. What this translates to in the day-to-day sense is fairly straightforward. If you have a pending immigrant visa case tied to one of the affected countries, this is the moment to get organized rather than wait passively. Gather updated proof of income, bank statements, employment letters, and, if applicable, a properly executed affidavit of support, typically filed on Form I-864. Consular officers reviewing reopened or reconsidered cases will still be looking at the same underlying public charge factors the law has always required. They simply cannot reject you automatically because of your passport. In practical terms, being ready with strong individual evidence puts you in the best position possible once your case moves back into active review. It is also worth mentioning that immigration attorneys and advocacy organizations are expecting a surge of inquiries in the coming weeks as word of this ruling spreads. If you believe your case was affected, documenting your timeline now, including when you applied, when you were denied, and any communication you received from the consulate citing this policy, will make it much easier for legal counsel to help you request reconsideration. While there have been some modifications to how quickly this rolls out, consulate by consulate, having your paperwork ready removes one major obstacle from the process. Beyond the individual case level, this ruling also matters for anyone simply trying to understand where U.S. immigration policy stands right now. In addition to these changes, we have seen other pieces of pending policy this year, including proposed rules around tax credit eligibility and public benefits access for immigrants, that show the administration continuing to focus heavily on public charge-related issues. Understanding how this court ruling fits into that bigger picture can help you anticipate what future changes might look like, even as this particular case likely heads toward an appeal. As a visa applicant or a family member waiting on someone overseas, this news might feel like a mix of relief and uncertainty. Relief because the door that seemed closed is now open again. Uncertainty because an appeal is still possible, and the practical rollout of this ruling across hundreds of consulates will take time. That's a completely understandable place to be, and it's exactly why staying informed matters so much right now. To summarize, a federal judge has struck down the 75-country immigrant visa ban, finding that it illegally denied visas based on nationality rather than individual circumstances. Denials based solely on this policy have been set aside, and the State Department is now required to resume case-by-case review. However, an appeal from the administration remains a real possibility, so this story is far from finished. For now, this is a meaningful win for families and applicants who had been caught in this policy, and it's a reminder of how much the immigration landscape can shift in a matter of weeks. That's all we have for this bulletin. The USA State Channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. Thank you for visiting us today, and we'll see you in the next video. If you haven't subscribed to our channel, please subscribe to the channel for more U.S. immigration update videos.